I have been working on a situation for years, for all the time I've been chairing this committee, which has been 16 years, that I believe that during the claim process, especially, in an automobile claim in particular, I just think the process right now in current law is heavily weighted in favor of the insurance committee to determine the value of claims. And I'm going to tell you why that is. I'm going to read something to you. This is from our own Washington Administrative Code regarding this issue. And this is just a piece of it, but it says, if the claimant chooses to take the lost vehicle to a repair facility where the overall cost to restore the lost vehicle to its condition prior to the loss exceeds the insurer's estimate, the claimant must be advised that he or she may be responsible for any additional amount above the insurer's estimate. To me, that says, and in practice, it has in fact been used to mean that that's just the way it's going to be. If the insurance company doesn't like it, they're not going to pay it, and there's not anything you can do about it. Ultimately, that's how it keeps ending up. Now, there are ways to do this. Of course, you can then, you can sue them, but of course, insurance companies have armies of lawyers where consumers often don't. So, and if you're talking about a $2,500 claim, you're not going to get a lawyer to take that, and I mean, it's just unfair in my view. Now, all I want to do, I don't want to make it unfair to the insurance companies. I just want to level this playing field and come up with some kind of a way to do that I have not figured out yet. And, so what I intend to do, I've got a few ideas. I'm going to work with stakeholders, and a lot of that will have to do with what we hear today. So that's why this hearing is important. And I do appreciate everybody sticking with the rules as I have, outlined them. And with that, I would like to start things off. There we go.
Thank you, Representative Kirby. Can you hear me now?
I can.
All right. My name is Joshua Green. I am testifying today in support of House Bill 1428. I worked for Geico for 7 years, starting when I was 19 years old, and included time in the field negotiating claims. For the last 8 years, I have worked for and managed certified collision repair centers. I support House Bill 1428 the way it's written. The Geico auto damage training I received was not adequate enough for me to do my job properly. I couldn't tell you what a proper repair was when I was an insurance agent, and it wasn't until I started taking manufacturer's training and worked with repair technicians on a daily basis to know what a proper repair was. First thing, I guess, going last is a benefit, because I get to hear the other testimonies. I would like to clarify the difference between a repair procedure and an OEM position statement. OEM position statements are just that. They're statements on the OEM's position in regards to certain things like parts. Nothing about this bill has a position statement. It's not a parts bill. It's a repair process bill. Now, OEM repair procedures, they do come out, and they come out looking better than IKEA furniture instructions, to be completely honest with you. It gives you the exact line where to cut the sheet metal. It gives you the exact place on where to put a rivet. Or in the case that Jeff was talking about with the Seabockens, it gives the 104 spot weld points that Honda Fit roof was supposed to be welded onto. Nothing about this bill is about parts, and I would like to keep the language in the bill the same. My advancement opportunities within Geico relied on writing the lowest possible repair, controlling rental costs, and CSI scores. We were not rated on safety of repairs. I had control over every single one of those metrics, including CSI, but by deciding who did and did not get a CSI survey. According to their own representatives during last year's legislative session, insurance companies are not vehicle repair experts. Vehicle manufacturers are the repair experts. Vehicle manufacturers spend hundreds of millions of dollars each year developing, designing, engineering, and testing their vehicles to be crashworthy in the event of an accident. Vehicle insurance companies like Geico and State Farm, they sell insurance. They're not in the business of designing vehicles or repairing vehicles. Furthermore, as Jeff indicated previously, insurance companies cannot be sued for how they repair or for how they dictate the repair should happen. And yes, insurance companies can, will, and do dictate repair decisions by deciding to not pay for the procedures and passing those costs onto the consumer or shops. Collision centers need the manufacturer's repair procedures and specifications. Thank you for your time.
Anybody hear me and see me? Thank you, Representative Kirby, and members of the Consumer Protection Business Committee for the opportunity to speak today. My name is Jackson Clemens, and I'm here to testify in support of HB 1428. I've worked in this industry for 18 years for 4 major insurance companies here in the state of Washington, as well as 4 body shops here in the state of Washington. Most recently, I worked as a senior auto damage adjuster for American Family. And during my time with American Family, I didn't feel comfortable with a lot of the things that they did in terms of the claim handling. Myself and my coworkers basically received no hands-on training at body shops, ICAR class training, or in-house training with body shop technicians during my tenure there. Instead, we were mainly trained on how to negotiate down claim settlements as low as possible. During my day-to-day operations at American Family, my directive was to never match a body shop's estimate, and I was directed by management as well as my supervisor to negotiate down the cost of the claims wherever possible. My supervisor's exact words to me were, "You are a claims adjuster, and your job is to adjust down the repair estimates." This constantly left my cost estimates short, sometimes severely, of what the shop repair invoices were. Consumers were left with the short paid claims, but again, American Family did save money. The last straw for me was working at the insurance industry, and why I've moved back to the body shop is I was out at a very small mom and pop body shop in South Seattle. There was a Toyota 4Runner with the left front frame rail that was crushed over and completely kinked, and the body shop wrote to repair it. And it easily needed to be replaced. If you're not familiar with frame rails, there's one on the left and the right side of every engine. It's pretty much the main structural component of a vehicle. I brought this up to my supervisor saying this absolutely needs to be replaced. This is a safety component. People could get seriously injured or killed if this was repaired the way the body shop wanted to repair it. Based on my previous experience, I knew that it had to be replaced. And my supervisor said, no, American Family is not liable for how a body shop repairs the vehicle. This really left a bad taste in my mouth, because the only thing I care about, whether I work at a body shop or an insurance company, is the safety of the occupants of the vehicle and how safely that vehicle can be repaired. I realized I was not working for the vehicle owner in regards to best repair practices and their safety, but to only worry about lowering the costs by any means. And I've left American Family obviously since then and gone back to a certified repair facility. And this is why I fully support the HB 1428 to make sure that vehicle and occupant safety is the #1 and only priority when repairing an automobile anywhere in the state of Washington. Thank you all for your time. I really appreciate it.